What are the two biggest conflicts in a medical malpractice case? You want to know the answer? Come join me for a walk in downtown Manhattan as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So here we have the World Trade Center in the background. You should be able to see that nicely. So what are the two biggest conflicts that arise in a medical malpractice case? I'll tell you. Number one, they are the facts of the case. Number two, they are the expert witnesses in the case. So what do I mean about the facts and having conflict? In these civil lawsuits, the facts are always in dispute. One side said they did something, the other side said, no, I didn't. Now, the second part of that is medical experts. In a medical malpractice case, we are required to have medical experts come in to validate and to confirm and justify that you have a valid basis for a case. In New York, we are required to show that, number one, your doctor and the hospital staff was careless. We are required to show that that carelessness was a cause of your injury. And we are required to show that your injuries are significant and or permanent. If we don't have a medical expert, then we can't go forward and we can't proceed with the case. And if we try and do that and get to trial without having a medical expert, the first thing the defense will do is immediately ask the judge to throw our case out. And if we can't put on medical experts to support our case, guess what? The judge will throw the case out. Okay, so now there are always factual disputes. So let's say, for example, this is a failure to diagnose breast cancer case. And now my client claims that on a particular day, she went into her gynecologist complaining of a lump in her right breast. Now, the doctor says, no, she never made a complaint of a lump in her right breast on that particular day. That is a factual dispute. My client swears that she remembers distinctly that when she went to the doctor's office on this particular office visit, she definitely told the doctor about a lump in her right breast, specifically at the 12 o'clock position. The doctor's notes don't reflect any of that. The nurse's notes don't reflect any of that. However, not only was the patient there, but the patient's relative was there as well. So now there's some confirmation that the patient actually made this particular complaint. How do we explain why there's a discrepancy in the fact that the doctor has no notes about it and a discrepancy about why there's no comment or notation in the nurse's notes? I can't answer that question yet, but that is the purpose of discovery, to explore these factual issues, to explore the conflicts that arise every single time there is an allegation that someone did something wrong. Now we have factual disputes. So who ultimately decides these factual disputes? Well, if your case goes all the way to trial, the answer is a jury does. It is the jury's function to decide who is more likely right than wrong. It is the jury to decide whether or not the doctor was careless and whether his carelessness was a cause of your injury. So the next greatest conflict we see in these types of cases involve medical experts. Our experts believe that the doctor was careless and caused this patient harm and injury. And now, when the defense reviews the same exact medical records, they review the same exact set of facts, they come to totally opposite conclusions. And you might be asking yourself, how is that possible? How could that possibly occur? You've got one set of medical records. How is it possible that two different medical experts with the same specialties can come to two totally different conclusions? Well, that's the great dilemma, that's the great problem that arises in these medical malpractice cases. If all of the medical experts reviewed the records and all came back with the same conclusions, then there would be no need to go further. Then it's obvious that either something was done wrong or, just the opposite, something wasn't done wrong. So why do we have such conflicts with these medical experts? Well, there could be multiple reasons, but the most important thing to focus on right now is when we have confirmation by a medical expert that you do have a valid case. That's the first step that will allow us to then go ahead and actually bring a case on your behalf. Did you know that in New York, we are not permitted to start a lawsuit for medical malpractice unless and until we have a medical expert who confirms you have a valid case? So now, months later, even years later, as the case progresses to trial, the defense will have all the records and all the testimony, pretrial testimony, reviewed by their own medical experts. Now, if those experts come to the same conclusion our experts have come to, well, guess what? That it likely is time to start negotiating the case. If, however, they turn around and say, no, we believe that nothing was done wrong, We believe that even if something was done wrong, whatever it was did not cause or contribute to your client's injuries. And even if we believe that something was done wrong and it caused harm to your client, well, guess what? We think that your client's injuries are not worth anywhere near what you believe them to be. So there are always factual disputes, not just about the facts and how these things came about. So we will always see these factual disputes, and we will always see these medical experts dispute whether or not certain treatment or lack of treatment represented departures from the standard of care. So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.